Utah takes a firmly pro-market approach to rent increases that's consistent with the state's overall landlord-friendly posture. If you manage rental property in Utah, you have broad freedom to set and raise rent, and the state has taken active steps to ensure that this freedom isn't restricted by local governments. The governing law is found in the Utah Fit Premises Act, Utah Code Title 57, Chapter 22, along with the general provisions governing landlord-tenant relations. Utah does not have rent control or rent stabilization of any kind. There is no state statute that limits how much a landlord can increase rent, how often increases can occur, or that requires landlords to justify the amount of an increase. Utah's legislative and political environment strongly favors property rights and market-based pricing. But Utah goes further than simply not having rent control. The state has enacted a preemption statute that specifically prohibits municipalities from enacting their own rent control ordinances. Under Utah Code Section 10.885.4, no city or town in Utah can adopt an ordinance that controls the amount of rent that a landlord can charge for residential property. This means that Salt Lake City, Provo, Ogden, St. George, and every other Utah municipality are legally barred from implementing rent caps, regardless of local political sentiment. This preemption gives Utah landlords certainty across the entire state. You don't need to research whether your specific city has additional restrictions, because none of them can impose them. The rules are uniform statewide. For month-to-month tenancies, the landlord can raise the rent by providing proper advance written notice. Utah requires at least 15 days' notice before the end of the rental period for changes to the terms of a month-to-month tenancy, consistent with the 15-day termination notice period we discussed in our Utah lease termination video. So if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver written notice by April 15th at the latest. Utah's 15-day notice period for rent increases is one of the shortest in the country, significantly shorter than the 30-day standard used by most states and dramatically shorter than the 60-day or longer requirements in tenant-protective states. This gives Utah landlords the ability to adjust pricing quickly in response to market changes. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date of the increase. While Utah doesn't prescribe a specific statutory form for rent increase notices, a clear written notice delivered by a documented method protects both parties. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing mid-term increases. Common mid-term increase provisions include escalation clauses, clauses tied to property tax increases, and clauses linked to CPI adjustments. Without such a provision, the landlord must wait until the lease expires and negotiate the new rent as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent early enough for the tenant to make an informed decision about renewal. If the tenant agrees to the new rate, a new lease or renewal is executed. If the tenant doesn't agree and the lease expires, the tenant either vacates or, if the landlord accepts rent, the tenancy converts to a month-to-month arrangement, at which point the landlord can implement increases with 15 days' notice. For week-to-week tenancies, the notice period for rent changes is 5 days, matching the 5-day termination notice period for weekly tenancies under Utah law. Now let's cover the restrictions that apply even without rent control, because unlimited freedom to set the amount doesn't mean unlimited freedom to set the motive. Rent increases cannot be retaliatory. While Utah doesn't have the most detailed anti-retaliation statute in the country, the state does recognize that landlords cannot use rent increases as punishment for tenants exercising their legal rights. Under the Fit Premises Act and common law principles, if a tenant makes a good faith complaint about habitability, reports a code violation to a government agency, or exercises any other legal right, the landlord cannot respond with a retaliatory rent increase. Courts evaluating a retaliation claim in Utah would look at the timing of the increase relative to the tenant's protected activity, the magnitude of the increase, the landlord's history of increases for comparable units, and whether the landlord can demonstrate a legitimate business reason for the increase. A landlord who raises rent by 30% immediately after a tenant files a health department complaint, while keeping rent stable for all other units, would face an uphill battle defending against a retaliation claim. The best protection against retaliation claims is documentation and consistency. Keep records of market comparables, operating cost changes, and property improvements. Apply increases uniformly across comparable units. And if you happen to be raising rent around the same time a tenant has exercised a legal right, your documentation should clearly show that the increase was planned independently. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Utah Fair Housing Act, found in Utah Code Title 57, Chapter 21, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, familial status, or source of income. Utah's inclusion of source of income is significant. It means that a landlord cannot raise rent specifically to push out a tenant who pays with housing choice vouchers or other government assistance. The Utah Labor Commission's Anti-Discrimination and Labor Division investigates fair housing complaints and can take enforcement action. A discriminatory rent increase, one that targets tenants based on any protected characteristic, can result in damages, penalties, and attorney's fees. Utah also has general consumer protection principles under the Utah Consumer Sales Practices Act that prohibit deceptive or unconscionable conduct. While this statute isn't commonly invoked in rent increase disputes, a landlord who uses fraudulent misrepresentations in connection with a rent increase, claiming that property taxes tripled when they actually increased modestly, for example, could potentially face a consumer protection claim. From a practical standpoint, Utah's rental market is one of the most dynamic in the country. The state has experienced rapid population growth, particularly along the Wasatch Front Corridor running from Ogden through Salt Lake City to Provo. And this growth has driven significant rent increases over the past several years. Salt Lake City is the state's largest rental market and has seen substantial rent growth fueled by technology sector expansion, population influx, and limited housing supply. The city's rental vacancy rates have been low, giving landlords significant pricing power. Annual rent increases of 5 to 10% have been common in the Salt Lake market during high growth periods, though the market can also correct during economic slowdowns. Provo and Orem, home to Brigham Young University and Utah Valley University, have student-driven rental markets where demand is strong and consistent. Landlords in these areas typically implement annual increases at the beginning of each academic year, and the student population provides a reliable base of demand. St. George in southwestern Utah has been one of the fastest-growing communities in the state, attracting retirees and remote workers drawn by the warm climate and lower cost of living relative to other Western markets. The rental market in St. George has tightened considerably, and landlords have been able to implement meaningful increases as demand has outpaced supply. Park City and the mountain resort communities have luxury rental markets with very different dynamics: seasonal demand patterns, high price points, and a tenant base that includes both year-round residents and seasonal workers. Rent increases in these markets are often tied to the broader tourism economy and can fluctuate significantly. One best practice for Utah landlords, even though the state only requires 15 days notice, providing more advance notice for significant increases is smart business. For increases above 5%, consider providing 30 to 60 days notice. This gives tenants time to plan and reduces the shock factor that leads to move-outs. The cost of tenant turnover, including vacancy time, cleaning, repairs, marketing, and the risk of a less reliable replacement tenant, often exceeds the revenue gained from a single month's higher rent. Retaining good tenants through reasonable, well-communicated increases is usually more profitable than maximizing rent on every unit. Another best practice: research your local market carefully before setting increases. Utah's rental market varies significantly, not just between cities, but between neighborhoods. A rent increase that's justified in a high-demand area near downtown Salt Lake City might not work in a suburban community with more available inventory. Use comparable rental listings, property management data, and local market reports to ensure your pricing reflects actual market conditions. For Utah landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The housing authority evaluates whether the proposed rent is reasonable for the market by comparing it to comparable unassisted units. Submit rent increase requests to the housing authority well in advance of the desired effective date to allow time for the review and approval process. Utah requires landlords to act in good faith in the landlord-tenant relationship. While this general obligation doesn't create a specific cap on rent increases, it does mean that a landlord who uses rent increases in a manner that violates the implied covenant of good faith, such as using increases strategically to target specific tenants for improper reasons, could face legal challenges. For the complete guide to Utah rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord-Tenant Law series.